And Emily Schaeffer will be our next witness, and she will continue along the same lines as Joseph has presented us with.
No.
Thank you, Emily.
Thank you, Madam Chairman. Thank you. Good afternoon, ladies and gentlemen of the jury, members of the audience. My name is Emily Schaeffer. I'm a lawyer practicing in Israel, and I've been asked to testify to you today about the separate legal systems for Palestinians and Israeli settlers in the West Bank. What I'd like to do first is just outline very briefly the establishment and jurisdiction of those courts, and then I'm going to do essentially a side-by-side comparison of the Israeli civilian court system and the military court system to show you how what ends up happening is that two people living in the same territory who commit the same crime can be tried in vastly different systems that produce vastly different results. So in the first few days of the Israeli occupation of the Palestinian territories and other territories, Israel established military courts. Now, indeed, under international law, specifically the laws of occupation and the Fourth Geneva Convention, the occupying power is indeed allowed to establish properly constituted non-military courts to try security offenses. However, Israel has both expanded and narrowed the anticipated jurisdiction under that law. When I say expanded, I mean that Israel has expanded its jurisdiction to non-security related crimes. So that means that over the years, in fact, a large number of the crimes that have been brought before the military courts include such things as traffic violations or theft, things that are clearly not security related. Now, it's true and it should be noted that this is starting to change over the last few years, but if we look at the courts over time, over the 44 years they've been in operation, a significant portion have been non-security related crimes. When I say that the courts have narrowed that jurisdiction, what I mean is that under Israeli military orders, the military courts have jurisdiction over any offense committed by any person in the occupied territory. However, under Israeli military legislation, Israelis and foreign citizens with tourist visas to be in Israel are tried, are handled by the Israeli civilian courts and the Israeli civilian system. So, what ends up happening, now I'd like to show you what the two systems look like, is that, and pardon my choice of gender, let's say we take a Palestinian man and an Israeli settler man who have committed, let's say for the sake of argument, the crime of manslaughter. Same crime, same territory. The Israeli settler will be arrested by the Israeli police and he'll be interrogated by them. If he chooses to see a lawyer, he'll be brought he'll be allowed to see or speak to his lawyer without delay. There are some exceptions. That meeting can be postponed by 24 to 48 hours. But, and in security cases, which is generally not applicable to Israeli settlers, but in security cases, that meeting could be delayed by up to 6 days, or even 10 days with the permission of a higher authority, 21 days with the permission of the Attorney General. The Palestinian in the military court system can be denied access to his lawyer for 30 days. And additionally, because in many cases the lawyers are Palestinians, they may experience difficulties in accessing their clients, which could delay the process of having this meeting for even more than 30 days. The Israeli man, if arrested, if held for further interrogation, must be brought before a judge within 24 hours in order to decide whether or not the arrest can be extended. The arrest can be extended for up to 15 days at a time, not to exceed more than 30 days, or up to 75 days upon approval by the Attorney General, 90 days upon approval of a Supreme Court Justice. That'll be relevant, I'll explain in a second. In the military courts, the Palestinian can be held for 8 days before being brought before a judge to see whether or not his arrest can be extended. His arrest can be extended for up to 30 days at a time, for a total of up to 90 days, or even 180 days upon the approval of an appellate court judge. And I want to make that distinction because in the Israeli system, the Supreme Court is the court of last resort. It's the highest authority, and it requires a justice from that authority to extend the Israeli settlers' detention, whereas in the military courts, only an appellate judge would be required, even though the Supreme Court of Israel is also the court of last resort in that system, court of last resort. There's also a process of remand or arrest until the end of proceedings. That's when the prosecution has reason to believe that the person presents perhaps a flight risk or will cause harm to the public, imminent danger. And in the Israeli system, the Israeli settler, for our purposes, could be held for a period of 30 days each time, not to exceed 9 months. If the arrest needs to be extended, if the proceedings are going longer than 9 months, the prisoner can be held for another 90 days upon, again, the approval of the Supreme Court. In the military courts, the Palestinian prisoner can be held until the end of proceedings for 2 years before a higher authority will need to intervene to extend for up to 6 months. Now, these are very technical time periods, but it's clear that the systems are extremely different. I'd also like to talk about general procedures.
Could you do that very briefly?
I believe I have 10 more minutes. Is that true, Madam Chairman?
No, it's not.
I was told before that I would have 15 minutes. I'm going to have to then do this incredibly speedily, which I'm not sure is possible.
You can do it. I know you can.
So can you tell me
what do
then?
they say? Yes, we can.
Yes. And then we saw what happened after that.
Because we do. Well, actually, I read against that.
No applause, Mr. Tutu. All right. I'm going to do my best, but I might break some rules. All right. Thank you. All right. So in general, I want to talk about, as briefly as possible, several major, thank you. Several major areas of the international standards of due process, which are violated in the military courts. And again, I'll demonstrate this by comparison. So when we look at the right to defense counsel, in the Israeli civilian system, everyone has the right to a lawyer, to a defense counsel. And if a person cannot afford a lawyer, then, as we all know from many of our systems, a lawyer will be state appointed and state funded for that person. In the military court system, there is a right to defense counsel, but there'll be no attorney appointed or funded for a defendant in the Palestinian system. Now, in practice, very few military judges are willing to entertain hearings of substance without an attorney representing a defendant, but some proceedings do continue without attorneys being present, including arraignments, which leads us, of course, to the right of a defendant to know the charges against him or her and to prepare an effective defense. That is inhibited by the fact that these lawyers oftentimes only meet their clients at trial, don't have time to prepare their defense. And in addition, when we look at the language issue, which comes up so often when we talk about this conflict and these areas, all the proceedings in the military courts, just like in the Israeli courts, but where Palestinians are being tried, are in Hebrew. All the judgments are printed in Hebrew. The laws are in Hebrew. It's often very difficult to access the judgments. Not all of them are published. And in addition, the interpretation that happens during the court hearings is conducted by Bedouin or Druze soldiers who have no legal training, who have only several days of interpreter training, and who, as they have testified to many human rights organizations, generally interpret the gist of the hearing. Public scrutiny is also an issue, and it's a right. It's very, very important to due process that hearings be public and that they be recorded. In the Israeli civilian courts, the courts are open to the general public. There are closed hearings for specific sensitive issues, including for minors, but generally they are open for as many people as can fit in the courtroom. The judgments and verdicts are published and easily accessible. In the military courts, only 2 family members of each Palestinian defendant are allowed to enter and be present at their hearings. Any member of the public cannot just walk in because the military courts are held on military bases, and prior approval is necessary and not always granted, not only to Palestinians but also to the Israeli public. So it's safe to say that these courts fall under far less public scrutiny than their counterpart, the Israeli civilian courts. It's also very important to note the difference between how minors are treated in these two systems. And I hope that some of my colleagues may address this more in some of the other testimonies. But if adults fare drastically differently in each of these systems, minors fare even more differently in these systems. Only last month, October of 2001, did the Military Advocate General raise the age of a Palestinian minor in the military courts to 18. Before that, it was 16.
You mean 2011?
Did I say?
You said 2001.
I'm sorry, last month was
2011.
in 2011. Yes, thank you for that correction. That's right. So until last month, in the military courts, children that were 16 and over were tried as adults and penalized as adults. This change is obviously wholeheartedly welcomed and a large improvement, but nothing else has changed, and the treatment of minors is still drastically different. So for instance, in the military courts, a child aged 12 or above can be tried and penalized, whereas in the Israeli system, children under 14 have no criminal liability. There are several other differences in those systems, including, for instance, that in the Israeli system, a child's or a minor's parent is required to be present during interrogation. That's not the case for Palestinians. And there are several other differences, which again I hope will be addressed later on in this tribunal. I should also just note, in terms of the quality of the two systems, who the judges and prosecutors are. In the Israeli system, judges and prosecutors are professionals, judges are elected or appointed depending on the instance. But in the military courts, up until the year 2002, lay people, as in non-jurists, were actually allowed to be judges. That has changed, like I said, in 2002. But judges are often simply lawyers who are serving reserve military duty. They are accompanied by a regular military judge in those cases, but still they make up part of the panel. And prosecutors include law clerks who are post-law school and pre-bar certification during their internship. And that drastically changes, obviously, the quality of both the judging and the prosecuting in those courts. I wanted to get a little bit into secret evidence and administrative detention. In the interest of time, I won't. I will just mention very briefly that secret evidence is an exception to the rule in the Israeli system. It usually applies only to security cases, which, again, Israeli settlers do not usually fall under. And it is the rule in the military courts. Again, administrative detention, a handful of Israelis have been held in administrative detention throughout the history of Israel, whereas thousands of Palestinians have been held in administrative detention, that is, detention where charges have not even been brought against the person who's being held in detention. All right, trying very, very hard to speed it up.
Because we do have some questions that we want to pose to you.
That's great. I'll try and sneak some of my presentation into your questions.
Yes, please do. So if you could give us your concluding sentence.
I will. Thank you. In terms of the substantive law, I could go into great detail about the differences, but I will just say that there's an entirely different penal code in the military court system versus in the Israeli civilian court system. So that already tells you it's different. In addition to that, the penalties are different and are much more stringent in the military court system than in the Israeli civilian system. And even when they are the same, they aren't necessarily applied the same in each of those. In other words, that a Palestinian would still fare worse in the military court system than the Israeli settler would in the Israeli system. And I will just mention, in terms of a few examples, for example, the crime of manslaughter. In the Israeli courts, the maximum penalty would be, under Israeli law, 20 years. It would be life imprisonment in the military courts. That doesn't mean, of course, that the judges have to give the maximum penalty, but that's a possibility. And I just will very quickly highlight, in terms of the differences in law, that many of the crimes that are crimes in the military court system would fall under the category or the protection even of freedom of expression in the Israeli civilian system. For instance, the incitement to endanger the security of the area is a crime in the military system, even when the incitement was to nonviolently protest. Whereas in the civilian court system, the incitement would have to be to inflict serious bodily harm, for instance.
Emily, I'm going to have to ask you, please, because I know that there are at least 3 questions.
All right.
So,
for other examples, see me later.
Okay, great. Thank you.
I just will conclude with one sentence. No?
No. Let Mike conclude your one sentence in Michael's response.
All right.
Great, thanks.
Oh, you have to. Sorry.
I've stopped speaking.
You stopped speaking. Fine. It's all right. I think we can take it a little more slowly. I was on a delegation, you may or may not know this, in 2009, of independent lawyers from the United Kingdom who examined the military court system. And I want, in a way, if possible, just to convey the oppressive nature of that system. And in a sense, I'm giving evidence, and I make it clear that I am. You may disagree, and if you do, it's a quicker way of doing it. Normally, I wouldn't be allowed to do this. First of all, I want to take an example of a young boy aged 14, could be girl, obviously, throwing a stone against the wall, all right, who may never have done this before. What we discovered was this, that boy might not ever be picked up, but there would be a raid on a neighbouring village in the night by the IDF who would pick up boys of that age. They would be questioned, in inverted commas, in the back of a truck without any representation, taken to a place of detention without any representation, and then, over a period of time, unless they were prepared to confess and plead guilty, the amount of detention would be extended and extended and extended. And what tended to happen without legal representation was a confession, and that the military courts, for that age group and other age groups, 99% of cases resulted in pleas of guilty based on confession only, something that the United Kingdom has turned its back on, and that the sentencing almost invariably resulted in prison straight away for the 14-year-old. Now, is that a fair synopsis, or am I biased?
I think you have described the situation quite accurately, and I would even go so far as to add that what ends up happening in many of those cases, this is a tactic used by the Israeli military and general security service in interrogation, is that they would round up those youths and detain them for lengthy periods of time under horrible conditions, and demand that they give up names of people in their communities, perhaps even adults, who may have, as I gave the example before, incited nonviolent protest and other illegal security offenses, and then that will form the basis for the conviction of many of other adults and Palestinians who will be on trial, and secret evidence, that will be the secret evidence against them that will be used to prosecute. So that's indeed the case.
Yes, thank you.
I have a question, basically that relates to some of the aspects of what you very clearly outline in your paper, the dual and competing systems. And it's about when Mairead and I had the opportunity to actually see inside an Israeli prison. And we actually got a dose of what they would call Israeli justice, or I would say injustice, criminal injustice. With that having been said, what I saw inside the Ramleh prison, the women's wing of Ramleh prison, and you know, maybe there are reasons for it, but it was clearly a prison populated, or at least what I saw, of the men and the women were people of color who were inside the prison, very much like what you would see inside the United States that wasn't reflective of the general population. There was a prison-specific type of demographic that was represented in the prison. What does that tell us, or was that glimpse that I saw an accurate reflection of, say, for example, conviction rates that exist in these dual systems?
Well, it highlights two things that I'd like to mention. With regards to the convictions, sort of the easier of the question, the easier part of the question, it is true that the military courts boast a 99% conviction rate. That's
wow.
Of indictments that actually had a final judgment. And in the Israeli system, the number is just slightly less, but not by much, I believe 97%. But amongst Israeli settlers, which I think is relevant to the presentation that I've given, it's much, much, much lower. And numerous human rights groups have for years faulted Israel with its failure to bring to justice Israeli settlers for what they call ideological crimes, i.e. crimes against Palestinians. So I think that's a more relevant comparison than the overall number. But I think you also touch on discrimination within the Green Line in those prisons and in the Israeli civilian system itself. And I think some of my colleagues will get more into prisoners, hopefully in the next 2 days. But I will just say that there are formal and informal, there is formal and informal discrimination against Palestinian or Arab Israelis inside Israel. They are viewed through a security prism. And that means that more often than not, they would be considered security prisoners. Whereas again, Israeli settlers would far more likely not be considered security prisoners, and their treatment will be completely different. And they would therefore also be more of the kinds of prisoners you would have seen.
Yes, Jose?
You have talked about the lawyers and language problems. They are the translate service. Translate service. In the case of the language problem.
Is the question whether there's a translation service?
Yes.
In which system? In both?
In the police.
In the Israeli system?
In the judicial system, the lawyers.
For both.
Right, so there is, and I think I highlighted it less because it's less relevant when it comes to Israeli settlers, right? Because they would be Hebrew speakers and the proceedings will be in their language. But yes, whenever Palestinian witnesses are needed inside the Israeli civilian courts, technically there's supposed to be an interpreter. My experience is that there are often major problems with finding an interpreter, and that cases are postponed because of that. So it doesn't work very well in the Israeli system either. And I think I mentioned in the military court system just that the translators or the interpreters are themselves young soldiers who are native Arabic speakers, by the way, who often speak a different Arabic than the one that the defendants speak, significant enough that it could change the way or the ability of the defendant to understand the proceedings, and also they have no legal training.
Okay, we have one more question from a juror, and I understand the time, so please be brief in your question and response. Yasmin?
My question relates to the fact that while an occupying power has the authority to establish this kind of military court, would you consider, in your expert opinion, that due process is being satisfied in these courts? And secondly, what would be the impact of the extension of the court's jurisdiction to non-security crimes?
Okay, well, thank you for your question. In terms of due process, I think it's safe to say that the military courts do not uphold the international legal standards of due process on every single account. That includes the right to the effective assistance of counsel, the right to counsel at all, the presumption of innocence, the right to prepare an effective defense, the right to interpretation of the proceedings, the right to be tried promptly and with undue delay, and the right to a public trial, among others. It's very clear to me from studying the military courts for several years that these are not being upheld. And also, in terms of your other question about the extension to other crimes, it just means, and again, I did note that this trend is starting to change. The Palestinian law enforcement is starting to take up some of those crimes. But what it means is that this system has a stronger hold on the Palestinians in the entire West Bank. So it just means that there is more of this, you could call it oppression or simply unfair justice, and more importantly, that Palestinians are being tried by a court that is not a court of their peers for more and more and more crimes.
Thank you so much, Emily. And